Hello and a very warm welcome. There has been a flurry of tax notices, show cause notices worth 55,000 crore rupees that have been sent to gaming companies. We don't know the exact number of gaming companies that have got these notices, but some of the prominent ones, such as Gamescraft and Dream11, are fighting this out. The charges are that there was alleged evasion of dues arising out of GST, and these tax notices go back to 2017. Now, of course, these tax notices have meant a lot of stress not only for the gaming companies, but many are saying it is the return of retrospective taxation, something that raised its head some time ago, several years ago, against Vodafone, and there was a lot of hue and cry about it, and it's something that investors closely watch: consistency in tax policy. To be sure, the GST Council had clarified that gaming companies will have to pay 28% tax, but that tax was to be levied from the 1st of October. That was what was clearly stated. To make sense of this GST conundrum that the gaming companies are facing, its impact on the gaming sector, and what are the options for the gaming companies, and most importantly, is the Revenue Department in the right in imposing and sending these show cause notices with huge hefty penalties? I'm joined by Mr. Ashish Philip Ibrahim, partner in Lakshmi Kumaran and Sridharan, and Mr. Prateek Jain, national leader indirect tax, PwC in India. Thank you so much for joining in, Ashish and Prateek. Clearly, I'm sure both of you have been very, very busy. This has completely come out of the blue. I want you all to first break it down for us on what are the changes that the gaming companies now will have to comply with, considering the new tax rate has become applicable from October 1. Prateek, let's start with you.
Yes, so let me just clarify that when we talk about online gaming, we're talking about online real gaming, where actually you put money and you play a game. So let's say 10 of us come together, we put 100 rupees each, 1,000 rupees is the total amount, and that amount of 1,000 rupees is redistributed amongst the players after deducting the commission that the platform or the gaming company would charge. So there was an issue earlier, interpretation that the gaming company or industry was saying that what is taxable is only their commission income or the fee that they earn out of this 1,000 rupees in my example. Let's say if that was 50 rupees, they were paying 18% on this 50 rupees to say this is my service fee. Government, on the other hand, believed that this is what they call as a game of chance and akin to a betting or gambling, and hence what was taxable was the entire 1,000 rupees in my example. Entire 1,000 rupees was taxable at the rate of 28%. So that was the debate. In some cases, the High Court had taken a view in favor of industry, which is already pending in Supreme Court now. The matter is pending. In between, of course, GST Council examined this. They were of the view that should be taxed at 28% on the gross value. The law got amended from 1st of October this year. There are a few states still who have not passed the law, is what we understand. But 28% on the full value is the law which is applicable from October 1, technically October 1, 2023. And hence, the industry will have to, of course, pay that going forward unless the law itself is challenged in the court.
Sure.
For the past period...
Yes, please, go on. No, finish.
Yes, for the past period, the government believes that even under the earlier law, it was always taxable at 28% on the full value. Okay, even if the law.
So why is there so much ambiguity? So from whatever I've understood, until now the companies paid a small tax, an 18% tax on the fee they charged for offering real money games, right? Now that is changed to 28% tax on the entire amount collected from players in every game. So there's no real money, there is no skill-based every game, right? So this was the understanding. Let me come across to you, Ashish. So was there a confusion? Was there an ambiguity? Was there some sort of evasion? Was the law open to interpretation, or was it very clear that there is an 18% and there's a 28%? Because when we speak to the government is very clear that they are completely on the right side of the law in sending out these notices.
Yeah. To add on to government is very clear. It was always this thing. Last GST Council press release. Also, Revenue Secretary was making a point that it was a clarificatory amendment. But the point to be noted, this issue has been debated by GST Council for last 4 years. The 4 years GST Council, at least in the 7 meetings, discussed the issue. That itself shows that there was an ambiguity on the method how to tax the industry. 2 committee reports were submitted by GOMs on this point. That also shows that there was an ambiguity. Coming to the legal position as stood prior to it, the legal position said that actionable claims other than betting, gambling, and lottery. The only action claims in relation to betting and gambling was taxable. Online games of skill are nowhere covered under the betting or gambling. When the state laws were banning the rummy in Kerala, Tamil Nadu, or in Karnataka was challenged, the court held whether the games are played offline or online, once it's a game of skill, it's not betting or gambling. The general law jurisprudence will be having an impact while deciding, interpreting the term betting and gambling in the GST. According to us, the interpretation canvassed by department is erroneous. To say the word betting in the Schedule 3 will include games of skill is erroneous. Yes, 1st October, they have made substantive change in the definition and valuation mechanism. Because of the substantial change, it has become taxable. Prior to that, it is not taxable. It is like Ola, Uber when they came, tech companies when they came, and for the commission or the intermediary part where they're paying the tax, deeming supplier was introduced in service tax regime, continuing GST regime. Something similar to that happened with the definition to deem these platforms as the supplier of the games to tax it. Without the deeming provisions and amendments, they could not have taxed in the earlier regime. Even the IT intermediary rules consider them as the intermediary facilitating a transaction. So, general understanding, interpretation of the betting in the past jurisprudence, and department view without amendment, it could not have been taxed. So, for the past period, without the amendment to tax it is incorrect.
Okay, sure. Prateek, I'd like you to come in here. So, do you agree with Ashish that there was ambiguity and the revenue department, their interpretation currently, what they're saying is incorrect, and it was very clear that there was an 18% and there was a 28% tax.
See, that's a debate, right? While industry has been saying that it's clear, the government has been saying it's not clear, right? So the debate was that whether online gaming was a game of chance or game of skill. The government believes a game of chance, and hence it is taxable in line with what is there for betting and so on. Where the industry said that it is game of skill, and that's matter which is already pending in Supreme Court. Of course, the high courts have decided in favor of industry. So I don't think it will be fair to say that the law was absolutely clear earlier, but I would say that it is tilting in favor of industry to my mind. Be that as it may, the past notices which have been issued, you have to bear in mind that they have also applied tax or sought to demand tax also on the winning amount. So let's say take my example of 10 people putting 100 each, and then I win as a participant 100 rupees more, and I put that 100 rupee again in the game. Now the question was whether that 100 again would be taxable or not. From 1st October onwards, it is clear, they have clarified that the redeployment of the winning amount is not taxable again. What is taxable is the gross amount when you put initially, and not the amount which you win and again deploy in the game. But for the notices which have been issued for the past, also includes this redeployment of the winning amount. Also, to say that there has been misrepresentation and there is a case for penalty, etc. Also, to my mind, is not correct, because as was pointed out that the GST Council was seized of the matter. They were examining this for last 2-3 years, and therefore everybody knew about this. There is a matter of interpretation, but not a matter of misrepresentation, and therefore any penalties and anything else, any penal consequences should also not arise. I would have preferred if our industry would, of course, have liked if there was absolute clarity to say that, okay, there was an interpretation issue of the past, we are not applying tax for the past, and from 1st October onwards, you pay 28%. That should have been perhaps a much better solution to this. But obviously, the government has another view.
Right. So this is return of retrospective taxation. They have gone back and they're doing something that they said that they won't do.
No, there is a little difference to my mind. See, in Vodafone case, what had happened was that government lost us something in Supreme Court, and they amended the law retrospectively. Here, that's not the situation. The law is amended from 1st of October. But what they're saying is, even under the earlier law, the way it was worded earlier, it
Yeah.
was taxed at 28%. So it's not as if the law is being applied retrospectively. It's just an interpretation of the government that even under the earlier law, it was taxable at 28%. So in that sense, it's different from let's say a Vodafone case. However,
In
you can say
application, it's the same. In
yes.
application, it's the same. So by law, legally speaking, that's probably correct. But in application, it's the same. So so now what next for the gaming industries, because gaming sector, because companies like Gamescraft is contesting this in the courts. So what are the arguments, Ashish, that gaming companies can make in this, and how long do we see this stretching on for? Also, I'll come to that later. The fallout of this episode on the gaming sector, because this was an up and coming sector, and the penalties are massive. The amounts we're talking about are huge. So, is it that the sector could probably just get killed before it could even take off? Ashish.
As, as discussed, the earlier definition of actionable state said anything related to betting and gambling is taxable. So games of skill offered online will not be covered under the betting. That is the core point which need to be substantiated by the Supreme Court. Supreme Court need to follow the earlier jurisprudence in the horse racing, rummy, etc., where they lay down the principles. What is a game of skill? What is a game of chance? Once it's a game of skill, the earlier interpretation was under Public Gambling Act. Same interpretation should follow under tax unless there's a deeming definition. Tax can define something to be game of chance or game of skill, whichever the way. But since when there was no definition, general interpretations should be applied to interpret. Supreme Court need to interpret to see what is the meaning of betting provided under the CGST law. First. Second aspect of whether supply is made by them or it's a facilitation of a transaction between the players. These are the two aspects on which the core arguments will revolve in the Supreme Court. When Karnataka High Court reaffirming, setting aside the SCN of Gamescraft, as beautifully summarized the various High Court and earlier jurisprudence of the Supreme Court. How long will it take? Litigation in India takes time. We need to await whether Supreme Court will set us the principle and ask the adjudicating authorities to look into it, or they will set aside the show cause notice, because multiple show cause notices have been issued. The matter has been, because in the GST Council, when they requested for a clarification, Council refused to give a clarification saying that it is litigation sub judice. Since it is sub judice, we will not interfere. So relief at the GST Council seems difficult. Said that for the future period, the regime has been settled, clarity has been provided, in new regime under TDS, new regime under GST, and new SRO regulations will help the industry to go further. But when there is an uncertainty, to clarify or to put at the mercy of the court will have an impact on the industry. We have seen the implication of filing an appeal going to the Supreme Court in the AGR matter. Once the Supreme Court come out with the ruling, government's hands were tied in the AGR matter to help the industry. In the end, government ended up buying the shares of the telecom company to support the judgment which they appealed to the Supreme Court.
So Prateek, coming to you on this, what changes now for gaming companies starting October 1? Also, the overhang of these show cause notices, what's the impact that you see on the sector for this?
So what changes from 1st October is very clear is that they have to apply 28% of the full value. Right? That means that the margin that they had will reduce. They'll have to find ways to see how do they deal with it. So the future is is clear. Although the GST Council has said that they will review it after 6 months or so. So if there is a complete adverse impact on the industry and industry is not able to cope up, then hopefully in 6 months' time, there'll be a chance for GST Council to review it, and they could potentially, take it back to 18% on the service fee as well. I mean, that's a possibility you cannot rule out. But as of now, 28% of the gross amount is what they have to pay. For the past period, unfortunately, there is no other option but to litigate. And while they can continue to go and plead with the council and the government that please withdraw this levy for the past period, but it seems increasingly improbable that the government will look at it. So they'll have to go for litigation. And based on all the arguments that are available with the industry, it seems that they will have a good case for the past period. But having said that, the quantum of amount is so huge that even if they have to do a part of that pre-deposit at some point in time, that itself perhaps will be extremely difficult, if not impossible, for many of these companies to do.
Right. Also, the fact that litigation takes a lot of time. There's a lot of backlog of cases, so a lot of working capital would get locked into all of these cases, right? Like if you have to make a deposit or anything, if you want to move forward with it. Globally speaking, Ashish and Prateek, both of you, what are the is India doing something which is completely out of the ordinary, or is this something that's practiced globally? And you look at the top 3 economies of the world, and what are the kind of legislations that gaming companies have to work with over there? Ashish.
Yeah. So internationally, the practice has been that tax the service fee which they get or the gross GGR. The taxing includes also 2 types of approaches there: tax the turnover or tax the platform fee what they earn. Internationally, the movement is to tax the platform fee, keep the tax rate neutral or lower so that consumer is protected, no the black market happens, industry is clean. The clear examples of this are UK. When the UK taxation rate was reduced from 15% to 7%, offshore companies which are providing or illegal betting which was happening, which moved, the revenue government was earning was tripled in the 3 years. It's a documented and report submitted in the UK Parliament. Similar effect we have seen in France when they moved from the turnover tax to taxing the platform fee. Mature GST regimes outside India, Australia, Singapore, etc., they tax the net earning or the net platform fee. So the approach we have adopted is slightly different from the approach, but we are mitigated to an extent from the initial proposal to tax only the deposit amount. So 100 rupees is deposited. I can play games n number of times, but tax will be paid only once. That is the concession government has given in the valuation of online gaming. But even that is slightly different, or it's a different approach from the other countries or other mature jurisdictions.
Right. So, Prateek, any lessons that India can take from, we heard the case of UK. Any other examples that you'd like to cite? If you could just elaborate a little bit on what Ashish said, because your video was frozen for a bit and we couldn't hear you very clearly. Your voice is also a little, I think there's some issue with your network. Prateek, can you please build on that?
Yes, so what Ashish was trying to say is that typically GST across the globe is charged on the service fee. The issue is that these platforms, when they provide you this facility of playing online gaming, what's the amount that they're getting as a service fee? It's not the deposit, because deposit is on behalf of the customer, which has to be redistributed. What I earn is only the service fee. And ideally, purely from a technical standpoint, that is amount which should be taxed, only the service fee, not the full deposit amount. But obviously, government is trying to sort of equate this with betting and gambling, and therefore they have a view. I think government needs to perhaps think a bit more about these kind of industry, including crypto and bitcoins and startup and new age industry, because those are the things which are evolving, and maybe have a comprehensive tax policy looking at all of this and looking at the international experience, rather than sort of having an ad hoc approach to taxation. That will be ideal as we go along and move to the next reform on GST, hopefully in next 1 or 2 years. Coming back to this, let us see how 6 months go by. I'm sure government will review the decision, but for the past period, there seem to be no other option but to litigate for the industry.
So, so there was a lot of furor after this 28% tax was announced. So there is still a case for lowering this tax rate, because the whole argument has been that this is betting, it's gaming, it's online gaming, and there's a premium attached to that. And if you're betting, then you should be ready to pay, willing to pay this kind of a higher tax. Also, the fact that it'll dissuade people from indulging in sports like that. Pratik.
Yes. So look, industry was okay to pay 28%, is what I understand, but only on the service component. Here the problem is that 28% has to be paid on the entire amount which you receive as deposit, right? Which is huge, really. I mean, the amount of service fee that you earn is a fraction of that, right? So 28% as a rate was okay, but the issue was more on valuation. And as I said, I do hope that the government would reconsider their decision over next few months, and try and see if they can go back to maybe 28%, but only on the service component and not on the entire amount.
All right. Okay. Thank you so much, Ashish and Pratik. Clearly, no easy answers there. But having said that, what's evident and what's very clear is that the law was open for interpretation. It was being followed in a certain way since 2017 until 2023, which is a long time. GST Council was in the know on how gaming companies are have taken on this law and the taxes that were being filed, and this GST Council clarification is what they have called it. GST Council clarification has put a spanner for the industry, and the government perhaps needs to reconsider how it is calculating its penalties while levying and while sending out these show cause notices, because if this goes on for a very long time, it could hurt the industry tremendously. Thank you so much for joining us, Pratik and Ashish, for that perspective. Of course, we'll keep tracking this story on Moneycontrol. And I'd just like to say that we were one of the first few people to point out that this is a case of retrospective taxation, and that the government must reconsider it. And we have been chasing the story. Thank you so much for tuning into Moneycontrol, and stay tuned for more news and updates. Thank you so much.
Thank you.